That's right.
This isn't about you. It's not about you.
That is correct.
Stop right now.
Good afternoon, Your Honor. Nicole Sadi. I represent Ms. Henderson, and she is now at the podium to my right.
Okay.
Nicole Henderson.
All right. I've received the assessment. Have the parties had an opportunity to view?
People have, Your Honor.
I have.
Go ahead. Any additional argument?
I'm sorry, I didn't hear the last few.
Any additional argument regarding her release?
Yes. Would you like me to go first?
Sure. It doesn't matter.
Okay. So Your Honor, I see that Ms. Henderson was extremely forthcoming with Mr. Statman during this assessment. While I'm looking at Statman's recommendation, these recommendations Statman are making include abstinence as well as outpatient treatment. I'm also looking at the law enforcement bond information form that I'm showing Mr. Cook right now. Thank you. Let the record reflect I showed it to him. Looks as though the police, the day that she was arrested, considering everything that they saw on the scene, was recommending a personal recognizance bond along with the scram tether. My client is willing to wear the tether as she understands this is normally a usual part of bond on a matter like this, as well as engage in AA. I understand that upon reading this report, it may put to somebody's mind, well, Ms. Henderson has been to rehab before. And in terms of the actual nature of addiction and rehab, Your Honor, I would argue that that is what we see when people are breaking a habit. There is a recommendation in here that is something she has not done before. Ms. Henderson has not attended Alcoholics Anonymous before and had that type of support and ability to make some sober connections. She has never done that before. And it looks as if Mr. Statman believes, professional assessment, that she would be a good candidate to go ahead and receive outpatient treatment combined with these other recommendations.
Your Honor, just two brief things. One, just a slight correction from what was just indicated about the information form. Where I believe the council looking, that was the people's original recommendation at the time of charging something we pulled out, not the police. Certainly that was the charging EPA's recommendation. The case, and when the case was first brought before this court, I asked for more than a PR bond for the reasons I indicated on the record. I know that doesn't factor into the court's decision today, but I just wanted to correct that. The second matter or the second piece that I wanted to discuss was in my review of the defendant's version of events as told to Mr. Statman, that they differ from what I believe the report and the evidence shows, not too dramatically, but in ways that I think it's important for the court to be aware of. Specifically, one part in the first paragraph indicates that the defendant completed field sobriety. She was only able to complete one of the three tests, to my understanding. The other two were not conducted or completed due to the defendant's lack of cooperation at that point. Admittedly, as the court's aware, she was incredibly intoxicated, so I'll just attribute that to her recollection. The event might not be the best. I don't think there was any malice on her part, but I think it's important for the court to have that corrected understanding.
I would like to respond. I will say that this is a paraphrase, and I would also like to say that Henderson.
Can I ask why you're going down the path that you're going down?
Yes, that he's paraphrasing that Mr.
Why are you paraphrasing? Why does
Nicole Henderson's attorney asks the judge to release her on a personal recognizance bond with a scram alcohol monitoring tether. She points to the assessment, saying Henderson was honest during the evaluation and is willing to follow recommendations like outpatient treatment, Alcoholics Anonymous, and alcohol monitoring. The prosecutor responds by correcting parts of the defense's argument and says Henderson's version of events differs from the police evidence, including what happened during the field sobriety tests and the circumstances surrounding her blood alcohol results.
Go ahead.
Okay, there may be an inconsistency here, but that doesn't mean there's an intention to be inconsistent, is why I'm going down this road. I think you understand. I don't go further. The other thing I did want to address for this court's attention is while Ms. Henderson acknowledges what the blood draw was, this blood draw was taken well over 4 hours after the initial arrest where blood alcohol rises. So it is not an indication of where her level was at the time of arrest.
So we're going to argue over those points?
Your Honor, in the bond argument we're making based on this report, I'm bringing forward based on science for my client to pursue.
Why do you think I asked for the assessment, counsel? Really? Why do you think I asked for the assessment?
Well, Your Honor, my job's to advocate for her.
And it'd be good if you did that. But why do you think I asked for the assessment?
I can only go by what you said. I'm not in your mind, but you said that you were concerned about my client's health. You're concerned about my client's mental health. You're concerned about her relationship with substances. And I believe you ordered the assessment because you wanted to be informed on those concerns before considering reducing bond. That's my belief.
Why can't I get arguments that go toward that?
This, in my opinion, this does go towards that. When we're looking at blood draw this high, the science shows, that
you know what? I mean, I'll let you go. I'm going to do what I want to do because I've been trying to get Miss Henderson out. I've been trying to do it in a safe way. I've been trying to do it with as many safeguards as I possibly can get. Trying not to miss anything. That's what I'm trying to do. I don't know that the arguments you're giving me help me any way in that.
Your Honor, respectfully,
that means I'm going to get none. So go ahead.
Your Honor, that is extremely unfair. And on the record last time, you said something that was unfair as well.
You know what? This ain't about you.
That's right.
This isn't about you. It's right. Not about you.
That is correct.
Stop right now. Deputy, take her back into lockup. Court's going to stand in brief recess. All right. Yeah.
As the defense continues arguing about the blood alcohol evidence, the judge interrupts and explains that the purpose of ordering the assessment was to determine how Henderson could be released safely with the right safeguards. The discussion becomes tense when the attorney says the judge is being unfair. The judge immediately responds that the hearing is not about the attorney, ends the exchange, orders Henderson back to lockup temporarily, and calls for a brief recess.
They rub my temples. Court recalls the case of People versus Henderson.
Good afternoon again, Your Honor. Raymond Cook for the People.
Good afternoon, Nicole Sadi, present, and my client is standing to my right.
I'm going to dispense with any further argument, if that's what we want to call it. What I'm going to do is defendant's going to be released on a personal recognizance $25,000 bond. Prior to release, she must be placed on a scram tether. So, ma'am, you won't get released right away, but they'll come and fit you with a scram tether, and then you'll be released. I'm going to order as a condition of her bond, your programming through, because you're employed at GM, right?
Yes.
And so I'm going to indicate also that the defendant is to engage with, is that GM or UAW program?
Well, it's called Rivers Bend. So I'm not.
It's called what?
Rivers Bend, the IOP program.
It's through GM.
Can I say something?
Hang on a second. I'll do it this way. That you're to engage with General Motors Employee Assistance Program, whatever their program is. You wanted to say something?
Yes. During my assessment today with Matt Statman, I had told him that I wouldn't mind. I would like to do the Dawn Farms program. That's $40 a week outpatient.
Here's what, so that we know. This assessment gives me one sort of side of you. All right. The Employee Assistance Program, I want you to engage with GM's Employee Assistance Program because it's available to you. Okay. I'll indicate that you're also to engage in Dawn Farm programming. I'll make that a condition of your bond, but I understand if one program is there, that might be a bit much. But okay, so I'll make that also part of the order. And then, is there anything else from either side on?
Nothing from the people.
May we briefly approach, Your Honor?
Yes.
Thank you.
Shall be done to necessary.
Back. These teachers are. Oh, because it shows my face scrunch. As if we have a quick in chambers.
I think we're doing that, sure.
Okay. All right. We're all set.
Thank you.
Thank you.
You're welcome. In council, we'll meet.
After the court returns from recess, the judge decides to release Nicole Henderson on a $25,000 personal recognizance bond. Before leaving jail, she must be fitted with a Scram alcohol monitoring tether. The judge also orders her to participate in General Motors Employee Assistance Program and the Dawn Farm Outpatient Treatment Program as conditions of her bond. The hearing concludes after both sides confirm there are no further issues. What do you think about this case? Let us know your opinion in the comments below.